Hello, welcome to the Salus GRC webinar, Understanding the New Reg SP Requirements, Incident Response, and Vendor Oversight Requirements. My name is EJ Yurzak. I'm a Managing Director at Salus GRC, a regulatory compliance and cybersecurity consulting firm based in New York, which helps hundreds of financial services firms around the country with their compliance programs, cybersecurity testing, and vendor due diligence reviews. My background includes compliance, law, and cyber. I'm very pleased to welcome to the webinar two esteemed panelists to share their knowledge and expertise with us. Joining us are Salvatore Papa and Christopher Mendez. Sal serves as the Chief Legal and Risk Officer for the Colony Group in Buckingham Strategic Wealth. In his role, Sal is responsible for overseeing legal, compliance, and risk management functions. Prior to joining Colony Group, he was on the board of directors of Buckingham Wealth Partners and served as the general counsel and CCO. He also previously served as the CCO for the SA Funds. Sal's worked in the investment advisor industry for 20 years, and prior to joining Buckingham in 2015, he was a partner and board member of a national regulatory compliance consulting firm. I'm also pleased to welcome to the panel Christopher Mendez, Senior Counsel in the New York office of Crowell & Moring. Chris is an experienced alternative investment attorney whose expertise spans the broader investment management industry, including advising on complex fund formation and transactional matters, as well as SEC examination and enforcement experience. Now, Chris comes to us with a lot of experience in structuring and forming a wide array of investment funds and other pooled vehicles, ranging from hedge funds, credit funds, hybrid funds, PE, real estate, digital asset, you name it. In addition to fund formation, Chris also has a lot of experience in corporate and fund-related transactions, including mergers and acquisitions and new financial product development. Chris, Sal, welcome to the panel. Thank you guys for joining.
Thanks, EJ.
Thanks, EJ. Thanks for having me. A pleasure to join. And I have to say, both you and Chris look good with your dressed up today. So sorry I didn't dress up for you.
Hey, not a problem at all. Everybody's looking good, and we have a lot of information to cover. So yeah, really appreciate you guys joining us here. Let's dive right in. The SEC voted back in May 15th, 2024 to adopt amendments to Reg SP. Reg SP was initially adopted by the SEC going way back to the year 2000 under Section 504 of the Gramm-Leach-Bliley Act. That's the act that we're all familiar with because it required federal agencies, including the SEC, to adopt rules and regulations requiring financial firms to send out notices to customers about their privacy practices, including disclosure about what information is being collected and with whom they're sharing that information. In some cases, giving customers a chance to opt out of that information sharing. This is the reason many of us are familiar with it, because we're all used to getting these privacy notices in the mail for the last several decades, stemming back to 2000 when this rule came into play. Well, Reg SP isn't just about sending out two-page privacy notices that end up in the trash every year. The rule also required financial firms to establish administrative, technical, and procedural safeguards to protect customer records and information. In short, since the year 2000, financial firms have been required to adopt and implement cyber policies, information security policies and procedures that are reasonably designed to ensure the security and confidentiality and integrity of the data in their possession, also to protect against unauthorized access, unauthorized use, those types of threats. So here we are 24 years after the adoption of those initial Reg SP rules for all financial firms. And I can tell you, in my experience, there are still a lot of registered investment advisors out there who still don't have a written information security policy or still don't have a written incident response plan, things like that. And I suspect the SEC likely realized this. So as I mentioned, on May 15th, 2024, the SEC voted to adopt final amendments to Reg SP. Now, during this webinar, we'll be discussing how these changes to the rule will impact compliance and cybersecurity programs and how firms should start thinking about planning. Now, here's what we're going to be covering today in the agenda. I'm not going to spend too much time on this slide, but again, we're going to be covering the components of the rule, and we're going to be talking about some tips and best practices, everything that's in the rule for the Reg SP amendments. Now, I'd like to start with a question for Sal. Before we get into that question, we've just launched our first polling question. So please take a moment to respond to this question. And Sal, a question for you. Before we get into the elements of what Reg SP would require for investment advisors, incident response plans, and vendor oversight, what are your thoughts on the rule, on the fact that so much of what is in this new rule was almost already required 24 years ago? Perhaps maybe not as specifically, but do you think incident response is something that advisors should have been addressing already? What are your thoughts?
Well, EJ, thanks for the question. I'm super curious to see what the audience comes in with in terms of this polling question. But this actual amendment to Reg SP is one I actually get excited about. Very rarely do I get excited about a new rule change, but this is one where you finally get a rule that matches what are regulatory expectations as well as what are kind of smart business practices, right? EJ, I know you work heavily in the cybersecurity area, and Chris, you're consulting with clients in this areas as well. Listen, businesses, particularly firms in the financial services space, they need to have an incident response plan. And regardless of this rule amendment, you want to help you prepare and respond to any cybersecurity or data incidents. And I also think I get excited about this rule because it finally gets into something or points to something that everyone is certainly attuned to and concerned about, right? Which is cybersecurity. And ultimately, this incident response plan can give you a lot of benefits, right? I think you can help identify breaches faster. I think you can minimize damage or the consequences of any breaches. I think you can help to protect your sensitive data, and also, like, ultimately at the end of the day, help to maintain that trust you have with your clients. So I do think that regardless of the rule amendment, firms should be having an incident response plan, but now this just gives you that additional push to have one.
Well said, Sal. I think that encapsulates it well. It's something that firms need to do from a business risk standpoint, regardless of what the rules say or don't say. After all, we're protecting client data, customer data, investor data, what have you, right? Let's take a look at the results of these polling questions. And Chris, love to hear your thoughts on this as well in terms of incident response plans. Do you agree with what Sal's mentioned? Firms should have this or not already?
Of course. Thanks, EJ. Yeah, I absolutely, wholeheartedly agree. One consideration is that incident response plan is really the other half of the equation. When you think about implementing cybersecurity, privacy, data protection protocols and frameworks within a firm, regardless of size or complexity, responding and having an appropriate incident response plan, or however you frame your reaction, proactive or reactive, to a breach or a potential breach, is really the other half of the equation. So, I wholeheartedly agree with what Sal said, and I think that a proper and tailored incident response plan is really part and parcel with having the framework to begin with.
Yeah, I think that plays out in the polling results that we have here. Percentage of firms, certainly as expected, do not have incident response plans addressed already. And those that do are not necessarily addressing breach disclosure, breach response, some of the components that we see in these new Reg SP amendments. And so I think what this tells me is that even firms that have some policies in place still have a little bit of work to do. And there are also some firms out there that, can't wait much longer to start having incident response plans in place.
Well, this is great polling results for this presentation because, right, we've got a couple of items that hopefully we can get people closer to what you do need to include in your incident response plan, and hopefully we can lay some of that foundation to get you going.
Yeah, absolutely. And as Chris was mentioning, firms need to be addressing cybersecurity. They need to be addressing incident response. Chris, it's interesting because your background also encapsulates private fund advisors, and we'll get into that in a moment when we talk about the scope of who this rule applies to and who it doesn't apply to. But cyber rules have been coming out from the SEC and rule proposals and rule adoptions for the last several years. The SEC appears to be coming at it from different angles, trying to address broad segments of the market. You can argue in somewhat of a scattershot approach, but also trying to encompass the entire span of cybersecurity. Back in December 2023, cyber rules for public companies went into effect, requiring them to disclose, material cyber incidents. We have the, cybersecurity risk management rules for all investment advisors that are still in a proposal stage. We may see, further action on that later this year. That remains to be seen. But what are your thoughts in terms of, the private fund sector in particular, and maybe the types of data that private fund advisors have? Do you think there's a reason maybe the SEC left them out of Reg SP, or do you think there's something else in play here? Do you think it's the fact that private funds are going to be covered in the other cyber rule? What's sort of the reason? What are your thoughts?
Yeah, of course, EJ. So I would say, to start, as a broader trend observation, if you will, I think it's no secret over the past few years there have been many headline-grabbing security or data breaches at large financial institutions, whether or not they're registered with the SEC or serve the same types of clients that Reg SP is meant to capture. Several of these incidences have included direct assessments on chief information security officers. So it's gone beyond just your routine exam or enforcement, and has looked to other areas of the law to assess liability, if you will. So I think that's a broader trend. I don't think that's unique to SEC registered investment advisors, whether they're advising private funds or other asset classes, types, or types of investors. I think as a general matter, regardless of whether or not you are registered in managing or advising private funds, you will be captured to some extent by, either at the federal or the state level, by similar or overlapping or more stringent rules, right? So I think specifically with respect to private funds, yes, although 3C1, 3C7 exempt, 40 Act exempt funds are not directly applicable, there's certainly some indirect applicability and overlapping applicability with other rules, regulations, specifically the Advisors Act, Rule 20647, of course, we're all familiar with that. And then, of course, there's the FTC and some other overlapping related regulations. So I would say certainly not out of scope entirely. And I think Sal mentioned at the beginning of the webinar, referencing just best practices and industry best practices. So yes, while you may not have direct applicability, I think you'd have a tough time being opposite an examiner at the federal state level, or opposite a client, or opposite a potential allocator on a DDQ or an RFP, and to go through that process and discuss this particular aspect of your business, and to not discuss some form of incident response plan, cybersecurity, data protection protocols. I mean, that would be a really tough conversation to have. So yes, exempt, but.
Right. Yeah, with a little asterisk there. I think I'm glad you mentioned DDQs, because, again, even in the absence of a federal or even a state regulation concerning incident response, your investors, your clients, are likely to be asking, what are you doing with my data? What are you doing to protect and safeguard my data? And firms need to be able to come up with a confident and sound answer to that question, regardless of what the rules say. And so I think we certainly can't let the regulatory tail wag the dog here. I think we need to be developing controls for the protection of the firm and for the protection of clients and investors. And it's only a matter of time before these questions come up in DDQs, and firms want to be able to answer those questions confidently. Well, let's break down the rule itself. Let's get into the weeds here. The Reg SP amendments that were adopted by the SEC this year contain four main components. So we can distill this rule into four components, four buckets, if you will. Number one, developing an incident response program. Number two is the breach notification requirement. Number three, service provider oversight. Again, something that we've seen the SEC try to tackle in other rulemaking and regulatory initiatives. It's also been in a number of risk alerts, enforcement actions, and so forth. And then finally, as with many rules, the associated record-keeping requirements. So we'll talk through some of that, but again, with any rule that the SEC comes out with, there are going to be additional books and records firms have to maintain to evidence compliance with that rule. So that's not a surprise there. But let's start with the first one, incident response programs. Now I'll go to the next slide here. This is just to cover again what Chris mentioned. Who must comply? It's what we're really talking about here is customer information, customer data, and we'll get to this in a little more detail. But we're talking about investment companies. We're talking about registered investment advisors with natural person clients, specifically addressed in the rule. And we'll circle back to this point. But as Chris mentioned, 3C1 and 3C7 exempt private fund advisors, not strictly covered by Reg SP. But don't hang up from the webinar just yet, because fiduciary duty and a lot of what we're going to be talking about here in terms of best practices will likely apply to your firm. Let's move on to the next slide here. So developing policies and procedures. This is really the first part of the Reg SP amendments. We're talking about Reg SP, and we're talking about developing an incident response plan. Firms must develop and maintain comprehensive, I'll use that word very carefully, comprehensive written incident response plans, or IRP for short. The IRP has to contain policies and procedures that are reasonably designed, and again, I'm emphasizing certain words here that we're going to come back to, reasonably designed to help firms detect, respond to, and recover from unauthorized access to or use of customer information. I know that's a mouthful, a lot to unpack there. We're going to get into the weeds on each one of these provisions. Developing the policies, developing the procedures. Again, I want to dive into the weeds here on what that means, because, like I said, the policies have to be in writing, they have to be reasonably designed, and they have to cover detection, response, recovery. A lot going on here. Chris, a question for you. What do you think when you hear the words, reasonably designed? There are going to be firms of all shapes and sizes out there. Some firms are going to have, SIM tools. They're going to have incident logs. They're going to have, the latest and greatest technology and systems to capture what's going on from an incident perspective. But you're also going to have, small mom and pop advisors out there that maybe don't have a lot of money to spend on technology, don't have a lot to spend on the monitoring and the detection capabilities. What do we mean when we say, reasonably designed, not just for this rule, but for any rule for the SEC?
Yeah, sure. So I think when I think reasonably designed, I think commensurate with, right? I mean, I think it should be commensurate with the risks associated with your particular firm based on size, the business model, the types of data and underlying client data that you are routinely handling. So I think reasonableness from that perspective should be commensurate with, right? So you described various levels and structures and sizes, and I think reasonableness would effectively mean something that is commensurate with the applicability of your business. I think there are definitely a handful of elements that would be de facto reasonable, right, to have. So conducting periodic assessments as part of your incident response plan, having access controls and testing those access controls, data encryption, training your staff on your incident response plan. I mean, I think all of those collectively are all reasonable steps to take when you're drafting and implementing an incident response plan.
Well said. I appreciate that context. I think, reasonably designed, we see that in the compliance program rule. We see that in other rules. And it's this notion that there's no one-size-fits-all approach to addressing cyber, just like there's no one-size-fits-all approach to addressing compliance. And so, I think it's important, to not let that notion get lost, that hopefully the SEC will be judging firms' incident response plans and capabilities based on the size and shape of their firm and their business model, their client base, and so forth.
Tailored, right? Tailored, EJ. I mean, that's what you always hear. Tailored, right? Yeah. Tailored to your business, right? Like you right. may have adopted or have worked with your advisors to draft a policy, but you should spend time knowledgeable of your business to tailor it to your business. That would be reasonable. There's a lot of things that would be unreasonable, but for starters, that would be reasonable. It's tailored to your business.
Absolutely. And it's easy for the SEC to play, Monday morning, quarterback in the event of a breach, but firms can point back to the existence of reasonably designed controls, reasonably designed policies, procedures. That will be your saving grace if there's an issue down the road. Sal, I have a question for you that's a segue from this concept. We talked about the Reg SP amendments being specifically applicable to advisors with natural person customers as clients. The rule also applies to broker-dealers. It applies to transfer agents registered with the SEC. It applies to business development companies, but as Chris pointed out, there's an exclusion from the rule for advisors to 3C1 and 3C7 funds, although there could be state rules and other regulations in play. But for registered investment advisors specifically, what types of data are we talking about? What types of customer information, personally identifiable information, or PII, do advisors typically have that's worth protecting that is caught up in the scope of this rule?
Well, so, and I know we're going to get into this definition later on in the presentation, EJ, but first and foremost, right, we all have information that would be considered sensitive customer information, which a parallel but not exactly spot on, right, is this PII, right, personal identifiable information, which is defined at the state level. And it'll be interesting when we get to that nuance to explore that a little bit further. But I think the point being, advisors have this sensitive information, inclusive of, for example, social security numbers and otherwise, tax ID numbers, account numbers, et cetera. And so, this is a in developing your policy and procedures, you have to have an awareness that you have this information, and regardless of the Reg SP amendments, you do have information that you have an obligation to protect, both at the state level and the federal level.
Yeah, great point. I mean, there's a lot of information, and we'll get into the definitions here on the next slide. It's a great segue. Regardless of what a firm has in terms of information, certain protections need to be applied, and the definitions are going to be really crucial here. So when developing policies and procedures, I want to take a moment and define these terms, because I think when firms are developing these policies or maybe enhancing their existing incident response plans, it may be worth defining some of these terms because your obligations are going to derive from these definitions and from what data meets these definitions. So first, I'll just take a moment and define. So Reg SP, the amendments describe being applicable to customer information in a covered institution's possession or that is handled or maintained on the covered institution's behalf. What this means is, it's not just data that you're using as an advisor, not just data that you're using as a broker-dealer, but it's information that you collect, but also the information that you share with third parties that may be maintained on third-party systems to help service your customer accounts. That data is still in scope. And so it's important to keep that in mind. Customer information that you possess or that you share with third parties to help service your customer accounts, that is all within the scope of this rule, all within the scope of Reg SP. Now, Chris, what are some of the systems and places that you can think of that investment advisors might be storing this customer data? Again, whether we're talking about retail wealth management firms or even private fund advisors that have high net worth investors and so forth. What are some of the places this data may be stored?
Yeah, of course. Well, for starters, the obvious place is on the firm's shared drives and shared networks and housed within their own cloud-based data centers and where they house their actual data for the firm. So that's the obvious point. Email, firm email, shared drives and places like that, right? Your typical sort of operating systems within the firm's overall tech stack. Then, of course, there's a lot of places that you may not consider or think you're going to receive a lot of data from the clients themselves, and that can come in a lot of different forms. It could be investor portals. A lot of firms have intranet or some form of designated investor portal logons where information is communicated, which includes PII. It could be in CRM systems and relationship management software and platforms. It could also include third-party service providers and others that you interact with as part of the operation of and processing of client data. First and foremost, I think fund administrators. That's a very common place where you're going to see systems that are accessing or have the ability to retrieve sensitive client data information. And then, of course, also one other additional element to that is particularly in a lot of firms that operate in hybrid environments, right? You have to think about, as well, as if you have individuals who are on hybrid who work from home or have home offices, and there may be other areas where you could have some data leakage from that perspective too. So I think it's very important to have a good, strong understanding of your firm's total tech stack and just general third-party service provider relationship mapping, and that's probably where you're going to get at least a dozen areas where data is stored, captured, or transmitted in some fashion.
Chris, great overview, and something I would just point out here that we also sort of have thought through or uncovered that I'll just throw out there as kind of a watch out for, which is make sure folks aren't storing sensitive documents on systems that you're not aware are maintaining sensitive customer information or PII. Thinking through where someone may put an attachment or something that may contain that information, because that will change, how you might need to address that. I'm curious, actually, EJ and Chris, as you're, helping clients prepare these incident response plans, which simply put, right, it helps somebody prepare, respond to, and recover from a security incident. What are some of the things you all are putting in those plans? How do you think through framing or putting together those plans? I'm curious, based back to our poll question, as people are working through developing these policies and procedures, what are you all putting in ones for your clients and customers?
Chris, do you want to go first, or do you want me to take that one? Oh,
please, EJ, please.
Okay. Yeah, great question, Sal. What are firms putting into these policies? I think it gets to this high-level question of how detailed should one make an incident response plan. I think we've seen plenty of cases where the SEC has brought enforcement actions or issued deficiency letters to firms in examinations where firms are violating their own policies and procedures, and in some cases, the violation may be of something so specific that the firm didn't necessarily need to have that in the policy to begin with, yet they violated it because it was in the policy. So it goes back to the age-old thing. If you say you're doing something, you need to be doing something, which begs the question: how much should firms say that they're doing? Obviously, the rule requires certain things. It requires written policies about how are you going to detect and contain an incident. How are you going to respond to that incident? And obviously now with these amendments, how are you going to be responding? And that includes breach response. I think firms need to be, covering those components, but I also think firms need to be careful with, not getting so burdened with the detail. Whether you have desktop procedures behind the scenes, or what I often see is that firms have playbooks or runbooks specific to a given incident, whether it's ransomware or phishing leading to malware, things like that. If you have certain playbooks for certain types of incidents, that's where you can put a lot of the detail. But I think firms also need to be flexible and understand that not every incident is going to play out the same way, and you need to be able to adapt on the fly.
That's right. Yeah, and I would add to that oftentimes it's going to be substance over form and practicality, right? So there's going to be internal communication, external communication. If you learn from a third-party service provider that your underlying client data may have been subject to breach, you will then need to trigger your own internal communications. I think it's very important to your point about having a playbook or going through a dry run, understanding who is responsible for managing that process. It doesn't always have to be your general counsel or your CCO or even your chief operating officer, but there should be someone designated within the organization who will manage that process, who possibly has established relationships with subject matter experts, both in and outside of the firm. That could include having your outside counsel, your outside lawyers who are experts in data privacy, in the underlying reporting regimes at the federal and state level, knowing how to call upon those resources, particularly if there is a breach that is of wide applicability, right? Trying to then get time with your counsel to figure out what your underlying responsibilities are. It could be challenging. Same thing for having established relationships, even outside of having a required third-party service provider oversight program, but having those established relationships and line of communication, I think is critical for that exact reason of not being able to get a hold of certain service providers when you need them most. If it's a fund administrator, by way of example, and there's a breach, or a broker dealer, for example, that you trade with, and there's a breach, and there may have been included your specific firm's underlying personal identifiable information, that's not the time you want to be establishing relationships and trying to reach out and figuring out who's responsible and getting some form of communication. A lot of times, these firms, maybe in the earlier days, they may respond one-on-one, but typically what they'll end up doing is doing their own informal, internal formal assessment and then communicating more broadly, and you basically get email updates periodically, right? So also having in place, to the extent you ever have to provide credit monitoring to underlying breach individuals, right? Having those resources in place, going through dry runs, knowing who the designated people are, I think all of those are critical to establishing an effective incident response plan. It's definitely one of those things where you don't want to have to you don't want to have to be doing all of those things as it's happening. It's not a fun place to be.
Yeah, and that hair on fire moment when everything's hitting the fan, it's time is of the essence, and there's a lot of stress and just heightened scrutiny around everything. And yeah, absolutely agree. That's not the time when you want to be trying to figure out, all right, who do we call for breach investigation, forensic experts? Who do we call for outside counsel to help with the breach response, or who else should be involved from a risk assessment or technical assessment standpoint. I'm going to launch the next polling question, and this gets into drafting these policies and procedures. But as this polling question is up here, Sal, a question for you. When developing an incident response plan, and in light of what Chris mentioned, that there are a lot of roles and responsibilities and a lot of moving parts, a lot of players involved, what are some considerations that firms should be taking into account when determining how to develop these? Who's going to take the lead in developing an incident response plan? Whose input maybe should you factor in?
Well, EJ, I don't know if we're getting ranked on these poll questions, but this is a tough one. You're making everybody select one. Because I would say I would put in a F, which is all of the above, right? I think, as folks are thinking through their incident response plans, part of the objective there is assigning responsibilities, right? And all of these different folks that are listed here could have different responsibilities. Certainly, I don't know if your third-party consultant does or does not, but if you outsource IT or you have a key service provider like a Salus GRC, they may be part of that incident response plan. And so, I think as you're working through your policy and procedures, the key here is thinking through roles and responsibilities, right? And clearly outlining the responsibilities of the various stakeholders. And that's inclusive of IT staff, that's inclusive of legal staff, internal or external, and then communications and other areas. So I think you want to cast a broad net on this one, as well as spread the love, if you will, right? You want to bring in, whether you're a firm of 5 people or you're a firm of 1,000 people, you want to bring in folks from all different areas to be able to appropriately respond to an incident. And so when you're drafting these things, even if somebody's not doing the actual typing or pen to paper, they all should sign off on it and or review it to make sure you're all aligned.
Yeah, I like that, Sal. The concept of spreading the love and getting more people involved. I think I'm not sure if I'd call it love in terms of having an obligation to provide input and feedback to an incident response plan, but it is, to your point, very important to get input from all stakeholders. It's something that everyone at the firm is going to have a role to play. Frontline employees, IT personnel, cyber staff, outsourced vendors, and so forth. I always tell folks that everybody at a firm is in a position to stop a breach from happening in the first place, but also plays an important role in mitigating that breach and helping to contain and prevent the further spread. And that's really one of the things mentioned in the adopting release for the Reg SP amendments is having this notion of containment. What are firms doing to put out that fire and stop further spread? It's not to say that firms need to detail every single step that they're going to follow in that process, because again, in the midst of an incident, it's not always readily apparent what's going to happen next when I do X. But at least having a general game plan that you can follow is very critical. Let's take a look at the results of these of this poll. And as you mentioned, Sal, it's tough to just pick one. Let's see who's going to take the lead here. All right, looks like the brunt is going to fall on compliance.
It's always the way, EJ. Compliance always leads the way, I guess.
It's good to see that compliance is getting a seat at the table. Some folks may say, all right, incident response, that's a cyber function, that's an IT function. Let's let the cyber team take the first cut at it. But I think what's apparent here is that there are answers selected for all of these options. Even other got some love. So
Point.
A lot of people involved here to get an incident response plan to be robust and comprehensive, right?
Yeah. I was just thinking. I'm looking at this, and in the spirit of spreading the love, I see noticeably absent is operations and IR, your investor relations, your marketing team, who are often the front point for investor communications, and often that's part of this process. Operations, many of your heads of ops and ops teams have the relationships where you might have breaches. So, I would think those two groups as well would have a seat at the incident response plan drafting table.
Absolutely. Whether it's taking the initial pass or if they're involved in reviewing the first draft. But yeah, certainly getting that.
And it might be their data too, right? It's not uncommon to. Right. It's not uncommon in one of these incidents. It's very common for your own firm's data to be compromised, particularly if it's data that you've sent. By way of example, if you're onboarding a new service provider, it could be a broker, it could be a vendor, and as part of their process, they require you to send certain information about your firm. It could be information about your firm principals, and you send over their control information, passport information, things like that. So while they're not listed there, certainly they would also want to know and would require some input to the extent that their personal information is exposed as well, in addition to clients.
Absolutely. It's a compliance risk. It's an IT risk. It's an operational, and it's a reputational risk, if nothing else, when client data is involved. Let's talk about the breach response itself, because that's where we're going here. And that's the second bucket of the Reg SP amendments is this notion of breach response. One thing that's important to keep in mind is that while Reg SP refers to customer information, which is a very broad category, the breach notification requirement applies to a subset of that, known as sensitive customer information. It's a very particular subset. Some of the components are defined and some aren't. What are your thoughts on that? I mean, do you think, generally speaking, that firms should be required to report a breach for any data, or do you think it matters? What type of data? I mean, if it's a lunch menu on your network that gets stolen, really no risk, right? I mean, but if it's client data, different story.
Yeah, I think this is a tough one. It's a tough one. I mean, is it the date of detection? Is it the date of the breach? Do we know with certainty that there was a breach, right? If it's if we receive notification from a third-party service provider that there may have been a breach, they made a determination if there's enough of a likelihood that there was a breach, they notify you. When does the 30-day clock start? That process is tough. I think there's a pretty healthy debate, a lot of comment letters in the adopting release discussing this particular point, the 30 days, whether it's at the federal or state level, when you need to give notification. I think this is one that's definitely worth spending some time on when you're drafting both the plan itself and then the incident response plan, because 30 days can go like that in a real situation where you have some compromised data.
Right. I think it's important to keep in mind too that the 30-day breach notice deadline is the outer bounds of the breach notice. We'll get into that in a moment, but it's as soon as practicable, but no later than 30 days. And so you're absolutely right that 30 days can fly by, but the adopting release makes it clear that if firms have investigated the incident and have all the information reasonably necessary to include in that breach notice, they shouldn't wait until day 30 to send that out. They should be proactive and say, look, we have, by day 5, we know who got in, we know what they accessed, or perhaps what they didn't access, and we can make a determination. If you know that on day 5, the SEC is not going to like, the fact that you waited till day 30 to send out that breach notice. Now, we mentioned that the breach notice here is required to be sent for a compromise of sensitive customer information. I'm going to take a moment and give the definition there. It's a component of customer information alone or in conjunction with other information, the compromise of which could create a reasonably likely risk of substantial harm or inconvenience to an individual identified with the information. Now, that's a mouthful. What does that mean in plain English? Information is considered sensitive customer information if there's a high risk of harm, high risk of inconvenience. Inconvenience is hard to define, but so is substantial harm. Think of it as being particularly sensitive if the compromise of that information is going to cause a big problem for your clients, if it's going to cause a big problem for risk of fraud, identity theft, similar harms occurring. If the compromise increases the likelihood of those occurring, more likely than not, it's going to meet the definition of sensitive customer information, but it is still vague. The SEC rule release here does not actually define substantial harm or inconvenience. The SEC gives plenty of examples, but stops short of actually defining that term. And so it's vague, but it's not. I think it's one of those things where when you see it, right? I mean, it's you can kind of read through the lines and say, okay, well, this information being accessed, being compromised was, let's say, Social Security number, for example. Pretty clear cut. That's going to cause substantial harm or inconvenience if that gets out. But what about other types of information? In one of the footnotes here, let's see, footnote 121 of the adopting release, I made a note here. The SEC gives some examples of sensitive customer information. They're also clear that it's not an exhaustive list. So, pay attention to that. Social Security numbers, driver's license numbers, any types of, registration numbers, government password numbers, tax ID numbers, biometric records, other types of electronic, ID numbers, address or routing codes. Again, the list goes on and on of types of information. And the other part of that footnote, the next footnote actually, the SEC says that information may not be sensitive customer information on its own, but in combination with other data points could help to identify an individual. And so in the next footnote, 122, there are some examples, a name or a username, together with maybe a partial social or a password or a mother's maiden name. You get a couple of these data points together, and it's hard to argue that that was not sensitive data getting out there, because somebody could do some substantial harm with a name and a mother's maiden name and even part of a Social Security number, especially if it's the last 4 digits. Or if you have a username and a password, you get 2 data points there. Maybe the compromise of one on its own isn't enough, but both, substantial harm is most likely. Chris, you mentioned the this 30-day notice requirement, and I want to make sure that we spend some time on the interplay between federal law and perhaps state laws. Now, this 30-day breach notification requirement seems to be the SEC trying its best to take a middle ground. It's more restrictive maybe than I think 14 other states, less restrictive than the deadline in other states. How reasonable is 30 days? How much information do we really know about an incident in 30 days, or perhaps even less?
Yeah, it's to your point, in the adopting release, there was a lot of interesting data about the state by state requirements, specifically with respect to the notification requirement. And it looked like the SEC, in proposing and adopting, tried to strike a balance between the majority of where states lie, as well as where collectively individuals reside. So I think there were certain pieces of the adopting release and that were used as response to comment letters that said, well, 8 million people reside in this particular area, and this state happens to be part of the 30 states that do X, Y, Z. So there was some pretty interesting data in that adopting release about that point. Again, just to reiterate earlier, I think 30 days can go by very quickly. I think it is a long time. I certainly think you can have an effective response all the way through remedial measures within 30 days. But I would say it's certainly going to be incident specific. And then, of course, to the extent you need to rely on outside experts, subject matter experts, legal advisors, compliance professionals, it could be information technology and cybersecurity threat experts as well, right? To try to get all of that information assessed and determine what your reporting obligations are to your underlying clients. It can be challenging. I see. There's a question that came in on the mandated. Are you required or mandated to report potential breach to federal state agencies, and what agencies would be involved? So I think the answer there is that at the SEC, no. So that would be the answer there. But again, I think you do have to go and look at the state-by-state underlying reporting requirements to the state-specific agencies there. I don't know if Sal or EJ, you have any thoughts on that or familiar with that, but I think as part of the adopting release, notification to the SEC is not required, so that should help answer the federal question. And I think at the state level, you'd probably have to determine where if you have residents in those specific states and to what extent you're expected to report to an agency within that state. I suspect there's probably a majority or minority answer, and it might be buried in the adopting release, something to the effect of a majority of states do not require specific notification to the state agency. So that's probably the answer on that one.
Yeah, I think a great question. This is a particular example where it's about as close as we get to a federal data breach, standard. There's a patchwork of state regulations out there, 50 different, state breach notification laws on the books. Some are more stringent than what's in this SEC rule. Some are less strict in terms of what they require. There is this whole notion of, federal preemption, though, that, firms that are complying with the SEC data breach notification likely have a strong argument to say that they're complying with, their obligations to provide notice of this breach. There could be other issues in play if it's a jurisdiction in which a firm is, has a principal place of business. Maybe there's some additional jurisdiction there. But my sense is that the SEC's goal here, whether it plays out this way or not, is to try to come up with a one-size-fits-all approach to breach notification. There are specific, not just timing requirements, but the contents of what that breach notice has to include. But this is really an area where it's important to get counsel involved, because you certainly don't want to miss a step in the process when going through this 30-day breach notice requirement. The rule is very clear in terms of what it has to contain. But you want to make sure that you're also, to Chris's point, working with counsel to make sure that if any additional agencies need to be contacted, certainly not the SEC, but other agencies, state attorney generals and so forth, need to be notified that you're appropriately doing so. I want to make one additional point here.
EJ, just out of curiosity, but said differently your point. I have the adopted release. I pulled it up, and sure enough, the way that you framed it is excellent. So it says the final requirements provide for a federal minimum standard for data breach notification. So think about it that way. It is a federal minimum standard. So if a state has a higher standard than federal, and you are subject to that state's notification requirements or any other additional requirements as part of that state agency's adopted rules, then you'd likely have to also bridge that gap.
Yeah, so there's certainly an interplay between state and federal regulations here that are important to keep in mind. And like I said, it's very important to coordinate with counsel when doing a breach response. Your compliance team probably knows the rule in and out. Your cyber vendor probably knows the details of what was compromised and when. But in terms of the breach notice, you want to get those parts absolutely right. There is an exception here in the rule for the breach notification. And I want to make sure that we highlight this point. The there's a presumption of notification, meaning absent any evidence, if you don't have logs, if you just bury your head in the sand and say, well, I don't know what was compromised, there's a strong presumption in favor that notification is required to all of your customers. But there is an exemption that if you've conducted an investigation and determined conclusively that your data has not been and is not reasonably likely to be used in a way that would result in substantial harm or inconvenience, you don't have to provide notice. But there is a strong presumption in favor of that breach notice. Pay attention to that phrase, though, after an investigation. What that means is that you need to document that investigation if you want to take advantage of that exemption. Otherwise, if you can't conclude whether or not somebody got in or what they accessed, you have to provide notice to all your customers within the time frame. I don't want to spend too much time on one of these points here, but there is an interplay among the federal agencies where there's a national security exemption or public safety exemption, where if the Department of Justice reaches out and says, look, in the interest of national security, public safety, we don't want firms to be notifying their customers about this breach. It's part of a larger cyber attack that's going on. The Department of Justice can actually mandate that disclosure notice get delayed. But you will certainly be notified of that if the DOJ takes advantage of that. Moving on to the next slide here. I know we got a couple additional components to discuss, but obviously the policies and procedures, the breach notice, those are the big parts of the rule. The record keeping aspects of the rule, there's a list of rule records you got to maintain, but I want to make sure we spend our last few moments covering this vendor oversight, service provider oversight. Now, when we're talking about service provider oversight, it's interesting because there is a separate vendor outsourcing rule proposal that the SEC is sitting on. So the SEC has actually made the decision to move forward and adopt the rule requiring vendor due diligence of certain service providers that have access to your data. Now, at the beginning of this webinar, we talked about what some of those vendors might be. A CRM, maybe a fund admin, custodians. Think about all the vendors and third parties you're working with that have access to your customer data. The SEC is expecting you to be doing vendor due diligence of those vendors, initial vendor due diligence and ongoing oversight of those vendors. That oversight applies to sending out a breach notice if there's a compromise. And so one of the important things to keep in mind is if there is a data breach involving your vendor, who is going to be sending out the breach notice? Is it your vendor or is it you? And firms can contractually agree that maybe the vendor will send out that notice if it's on their systems. But as part of your oversight as an investment advisor, you need to be aware of who is contractually obligated to be sending that out, and then actually confirming or at least obtaining reasonable assurances through attestations or confirmation thereafter that they've actually sent out that notice. If not, that obligation falls back on the advisor. So keep that in mind. But I think we're going to see firms beef up not just incident response plans, but vendor due diligence policies and procedures as well. And if you're not conducting due diligence on your vendors, you certainly need to start doing that now, because these rules are going to be going into effect and are going to require it. It's also a best practice. Let's jump to, we're going to launch the next polling question here. And while we have the polling question up, just going to ask a question here again. In terms of due diligence, Sal, Chris, what are you seeing out there in terms of what firms are doing, perhaps what your own firms are doing to evaluate the risk of vendors? There's a lot to unpack in terms of how do you evaluate a vendor, but just curious, what are you guys seeing?
Yeah, well, maybe I'll go first, Chris, if you don't mind. I think, as you noted, Chris, at the beginning of the presentation, right, a lot of the higher profile cyber incidents, or perhaps the not so high profile ones, often are the result of a breach at a vendor. And so this component becomes critically important. And funny, EJ, as you pointed out, right, it's a little bit of a end run around by the SEC. We've got this vendor diligence rule sitting out there, and this one kind of seemed to push that forward without adopting that proposed rule. So it'll be interesting to see where that kind of goes. But you know, this vendor oversight concept is obviously important, and just from a practical standpoint, you know, I think what we've tried to do is sort of twofold, which is number one, whoever is that internal sponsor of that new vendor, right? They have to understand that this is part of the process. And so we build into the contracting process, right, a due diligence piece, right? So that you make sure you get sign off by those appropriate parties internally to do that diligence before that vendor is onboarded. And you also should take a look at, as you noted, DJ, what's that contract say around breach notification? And certainly with some vendors, as you know, you get more leverage over than others. Like you don't have much leverage over Microsoft, for example, versus a smaller vendor where perhaps you can get some of those terms in there around this breach notification item as required by this rule. So those are some important elements to be aware of or think about. And then I'll just share one other last tip, which is start thinking about tiering your vendors, right? What vendors of yours have PII, sensitive customer information, versus those who do not? There's a big distinction there. So,
I've to add to that, as a starting point, I have found the accounting teams to be highly effective at helping on this process, because any firm, regardless of size, you could have, just throwing it out there, upwards of 100 vendors in some form or capacity that touch your firm, and they all get paid. And so accounting often has a very robust list of the invoicing of all of your vendors. And so oftentimes you can get a nice spreadsheet where you can see every vendor that touches your business. And to Sal's point, you can then sort and assess based on some level of applicability. You can think and adopt some level of Form PF reporting requirements for operationally necessary businesses. You could use Microsoft and Google G Suite if you're operating on the G Suite platform as great examples, and you know, start there, and maybe you tally up your top 10 most high profile, most important vendors, and you go out and you start the dialogue. Most of them, in my experience, particularly on the broker dealer side, a lot of them have already ready to go packages, their cybersecurity data package that they can send, because they get this request so often. And you can simply ping your relationship manager and say, hey, please send me your cybersecurity or data package. And you can look to see when was the last time they had a SOC 1-2 report done. Maybe it's stale. You can ask about that. That will show some level of due diligence on your vendors that is related to this topic. And then on the contract negotiation point, I think 100% agree with Sal there. Very difficult. There's a whole, a healthy debate, again, in the adopting release on this point. A lot of comment letters on this point. It's very challenging to have a third party, the SEC, come in and tell you how to contractually enter into relationships. It's very challenging to do. To the extent you have leverage and you can incorporate into a contract some ability to at least have the service provider itself to have its own incident response plan or have its own notification requirement to you, very helpful. Desktop policies, I've seen those added to agreements and contracts related to that. So there are practical steps that you can take that, or at least good starting points on these rules.
Yeah, well said. I was happy to see that the the final rule struck that provision that was in the proposed rule that would have required firms to enter into specific contractual terms with like a Microsoft or an AWS, vendors like that. So sort of the SEC's nod. We are coming up on the end of the webinar, so I do want to leave a moment here just for final thoughts, including remarks from each of our panelists. Sal, if you'd like to go first, and then I'll kick back to Chris. A lot of information to cover, and I just want to mention one final thing too, that we've received a lot of questions, and if we did not get to your question during the webinar, we will certainly follow up after the webinar. But final thoughts, Sal and Chris?
Great. Well, first, EJ and Chris, pleasure to join you and work on this presentation with you. It's been a lot of fun. Secondly, I'll give you a plug, EJ. You all have put together a wonderful white paper, understanding the Reg SP requirements, a plain English guide. I'd recommend that one to everybody. I don't know if it's publicly available, EJ, or you can send it to folks.
Yep.
So check that out on their website. But I'll leave you with a couple, I guess, takeaways from my side, which is after you've gotten through getting those policies and procedures organized for kind of your incident response plan and vendor oversight, and you've worked through kind of the record keeping stuff, think through, I think, kind of some of the key practical tips, I think, which is one, get together an incident response team and do something even as simple as creating a distribution list about this is the IRT, the incident response team, right? So get you along with your colleagues to be that incident response team. That's one. Two, we mentioned it throughout the presentation, do some tabletop exercises, right? Get some of that practice, have some of those reps. You don't have to push it yet, but if you can get to a quarterly basis, I think that's fantastic. That's really paid dividends for us. Three, do a data inventory. I think, Chris, you gave a great tip. Pull the accounting records or what have you of vendors, do some data inventory, see where it's at, and then start thinking about who are the key mission critical vendors and who are those vendors who have PII or sensitive customer information. And then lastly, tap into your resources, whether that's Chris, EJ, or even free resources available out there. There are these things available accordingly. So again, thanks. And Chris, I'll pass it back over to you for concluding.
Yeah, of course. Excellent summary. A lot of great tips. We wouldn't be doing our jobs if we didn't scare the participants a little bit. So I would say one final tip, maybe spend an hour with your IT folks and look at your penetration and vulnerability testing and look at how many attempted attacks on your systems occur on a daily basis, and it'll frighten you. So I would just leave you with that.
All right, well said. Chris, Sal, thank you both very much for your time, for your thoughts and expertise. Thank you for all the attendees, and we will follow up afterwards for any questions that we didn't get to. Thank you all so much. Take care.
Thanks.